Do you think 50-50 custody is guaranteed in Washington? Well, that belief can cost you time with your kids. A lot of parents walk into divorce assuming equal parenting time is the default. They think if they're a good parent, they're automatically going to get 50-50. Well, over the next few minutes, I'm going to show you how custody actually works in Washington and what determines how much time you get with your kids. My name is Charlie Shane, and I'm a Washington State divorce lawyer. I help people manage custody conflicts all the time. And Washington doesn't even use the term custody the way most people think. It's about a parenting plan. And the court's focus is what is in the child's best interest. And what's in the child's best interest may or may not be a 50-50 parenting plan. Most parents walk in saying, I want 50-50, and they focus on what feels fair to them instead of what the court's actually looking for. And admittedly, in recent years, the trend is more towards 50-50. And courts want the children to spend as much time with both parents if it's in the children's best interest. But that's the issue. What is in the children's best interest? And the fact is, judges don't care about what's fair between the parents. Instead, they're looking at stability, history of caregiving, work schedule, who can provide consistency for the child. And if you don't align with these factors, 50-50 may not happen. This is why, when facing a divorce or custody situation, you need to build your case around what the court thinks about and not about what you think is fair. When it comes to custody disputes, here's what I walk through with clients. Step one, show your parenting history. You want to show your parenting history through documents, medical records, everything you can think of. And this parenting history involves doctor's visits, who takes the kids to soccer, who is going to the school plays, who helps with the homework, who does the laundry, who cooks for the children. Anything you can think of to show your involvement with the children. The second thing you want to do is create a realistic schedule. And I'm not talking about just saying, I want equal time. You really need to think about your schedule, the children's schedule, geography, logistics. These are all important factors when putting together a parenting plan. Once we figure out a parenting plan, then it's time to demonstrate stability. How do you demonstrate stability? Well, housing, consistency, your ability to co-parent. It's not just about equal rights. Step four, control your communication. One of the things that can limit your parenting plan is abusive use of conflict with the other spouse, which can negatively affect your children. The court looks at this sort of thing. You need to make sure your communication is, I would say, professional with the other spouse. Make it clear, concise, non-argumentative, and constructive. But most importantly, you want to be strategic early on. You want to do everything to move towards that final parenting plan. And a temporary parenting plan can help this, but is not the deciding factor. And you need to show the court that your plan is in the children's best interest. This is why I suggest involving a family law lawyer early on in the process. A good family law lawyer can help you with a game plan and can set you up for success in arguing your plan. If you or somebody you know is facing a custody battle, contact my office. We can set you up with a strategy session that can lay out that game plan and help build a foundation for success.